everybody. Welcome to not my studio, but we're making it work over here in Indiana, quite a ways from home for me. They're a lot further into fall here than we are back home, but that is a beautiful thing out here on the east. Lots of colors turning. I am obviously here for the Richard Allen trial, so I was able to go over to Delphi yesterday, take a look around just the downtown area, obviously some of the scenes that are critical to the case, the high bridge, the trail system out there. It really is a lovely time to be out in this area. Deer Creek is stunning. It's just a spectacular little spot. So I can definitely see the attraction of that place. When you have a nice day in the middle of winter and it's unseasonably warm and you want to go for a walk, yeah, I would have probably picked that too. Well, I got into the courtroom today for jury selection. Yay! Wasn't really sure what I was going to find, but it turns out they did have quite a bit of seating available, about 25 seats for the media and members of the public. So not too bad. There wasn't anywhere near the line I kind of expected there was going to be. I got there at about 6:30 in the morning. The courthouse opens at 8. The hearing was scheduled to start at 9. And maybe a dozen people were there before me. There were a lot more for Brian Koberger's arraignment, which quite frankly, it just to this day still kind of baffles me because, you know, it's just in terms of what's significant in a case, boy, jury selection is really, really important. And pleading not guilty, you know, it's a formality, but not necessarily that interesting from a legal standpoint. So did see some people that I knew. Lawyer Lee is there. Wonderful to see her and get to meet her in person finally. Lana from Truth and Transparency was there. Got to meet her. The folks from The Murder Sheet were there. Otherwise, pretty much everybody else that I saw and talked to was mainstream media, conventional media, different news outlets. We took all but one, I think, of the public seats that were available. So 24 people roughly in total. And they had a separate area reserved for family of the victims, for family of Mr. Allen, and so forth. There were, you know, quite a few of them there. They were back towards the back, so relative to where we were seating, you know, I'd have to like crane my neck to turn and look at them, which I just was not really inclined to do. So I didn't get like a head count or anything like that, but definitely representation there. I assume for the victims as well as for Mr. Allen. So I'm just gonna kind of get down to the main points right off the bat, and then I'll go in. Of course, I'm there with my yellow legal pad, so I got a ton of notes, and I'm pretty much just gonna go through that with you guys and see if you have any questions and stuff that I can answer. But I'll give you the bottom line right off the bat. They almost have a jury, guys. They're picking 12 jurors and 4 alternates. Today we got through an initial panel of 52 people, and they have 14 out of the 16 total already selected. It was a little bit surprising that there were a fair number of people that did not report any familiarity with the case, not seeing anything about it in the media, not knowing about it. Somebody was telling me in the line outside that might have been one of the reasons why they picked Fort Wayne in the first place, because in Allen County, apparently the media just didn't really cover the story very extensively. It was one of the least covered areas in the state. So there were quite a few people that had not heard of the case. On the other hand, there certainly were plenty who had. And of the ones that had, I'd say it was split probably about 50-50 between folks who said, I have an opinion, it's a firm opinion, and I'm not going to change it, and people who either said, I don't have an opinion yet, or I do have an opinion, but I'm still open. I'd be willing to change my mind. Of course, if following from Kohberger, how much weight can we really put on that? I don't know. It was really interesting, I will say, watching this jury selection after having followed that whole process in the Kohberger case with the change of venue and the jury questionnaire, the survey that had been done, and all the testimony we got about the psychology of decision making and bias and stuff like that, because I could really see a lot of those things happening in this court, the way that the process was kind of cementing people in certain positions, not necessarily inviting them to maybe say what they really think, kind of putting words in their mouth a little bit. But all in all, I would say so far I'm pretty positive on the panel as well as the jurors that have been selected. So that's where we're at, guys. They're going to have a jury tomorrow. At the close of the hearing, Judge Gohl said that what they expect to do tomorrow is to finish selecting the jury, and then they will take up the rest of the motions that are still outstanding. There are some motions in limine still hanging out there. I know the one about the defense's ballistics expert is still out there. Questions about who's going to be able to sit at counsel table or behind counsel table and assist. The state wants to have two law enforcement representatives that are not subject to the witness exclusion order. The defense is objecting to that. They say the rule says you get one, you should only get one. There's some issues as well that the defense raised about the fact that these two officers had both kind of collectively been involved in investigating the Department of Corrections, the conditions of Mr. Allen's confinement. And so it was particularly important that their independent testimony not be untainted by the others, because they could have, different versions or different perspectives on what it was that they saw. So that's right up the front, guys. Not gonna hold it back. That's really your bottom line. We're really, really close to getting a jury. So I want to go ahead and just give you a lot more of the details of what happened today, kind of fill in some of the blanks. Before I do that, though, I do have some shout outs that I want to give. Some folks that have been enormously helpful for me in terms of being able to get up to speed on the case, to find the legal documents, be able to read through them and get oriented and so forth, because as you know, this case has a little bit of an issue with transparency, and access to the court documents and the court file is one of those issues. This is not like Delphi Heard, where they kept a nice public website there with all the documents uploaded. Everybody could go and find them. It's not available through the courts online. So there are people who have been compiling them and making that available to the public. Those are the people I want to shout out very specifically. Sleuthy Goosey, who I think might be here in the chat. She's got a fantastic spreadsheet with a lot of the documents. Yellow Jacket, who goes by @CornDogCourt on Twitter, was very helpful to me as well, provided some links to a lot of different information. And then All Eyes on Delphi, who's maintaining a CSS webpage, basically with all kinds of links to not just the court documents, but some of the information, the other information that's been out in public, timelines, good things like that as well. So really wanted to shout out those people, because they have done a massive amount of work in making this case accessible, making those documents available, and just getting some good materials out there to help break down everything, all of the very many twists and turns that have happened in this case. Real quick too, you might notice in the chat, we got some new wrenches here. I am kind of committing to a fairly heavy streaming schedule here, and while my wonderful husband has certainly not abandoned me by any means, he's here in the chat now, love you honey, at the same time he's got a lot going on, and so help is always appreciated. So some of the folks who have been longtime good chat members here that were willing to help out, and I'm very grateful to them. So Moon Goddess, you'll see in the chat, Chinny in the chat, and then Excited Utterance, if she's able to make it over here, has a wrench as well. So yes, Jeff is not the lonely mod anymore. Jeff will have some mod companions. So thank you guys so much for your help. Just keeping things running smoothly. As you know, we are a free speech zone here. Not here to police people's opinions or thoughts or anything like that. We believe in the free sharing of ideas and discourse without fear. But at the same time, you know, I'm not going to show you my tits, so don't ask. And, you know, spam pops up and things like that. So very helpful to have the folks with those wrenches to help keep things running smoothly. So let's get into these notes, guys. So, like I said, I got there about 6:30 in the morning, and it was cold. It was really cold, windy, rainy, not particularly pleasant environment in there. But you know, whatever. We were able to cope. Didn't get too wet. But I am learning about the climate over here. Also, a little bit different than where I came from right now. The courtroom, I gotta tell ya, is not to my taste. It's not to my taste. The whole courthouse, it's an old classical style courthouse. It is quite beautiful. Looks like it was built probably turn of the century, you know, maybe late 1800s or something like that. Lots of marble columns, very classical style. But that was taken to a level that, to my personal eye, quite gaudy in the courtroom itself. Very neoclassical, you know, columns that don't support anything, lots of ornamentation, multiple layers of carved wood, kind of mimicking the Greek friezes that they would have on the walls, coffered ceilings, painted in probably 5 or 6 different colors, a big skylight with stained glass. The walls are green and white and pink marble. Just the whole thing is a little bit of an explosion, which is, to be fair, kind of Greek. It's how it was back in the day. All those statues that you see around and stuff like that, the archaeological stuff, those were painted in bright colors back in the day. So in that sense, it's somewhat authentic, but yes, tasteful, not to me. I found it honestly a little bit distracting, but you know, they had cushioned chairs though. I got to give them credit for that. When you sit all day, a cushion helps. It doesn't solve everything, but it definitely made things a little bit more comfortable. The capacity of the courtroom was 119 people, so plenty of room. The first panel was 52 jurors, so plenty of room for them. Press and media over on the right-hand side of the courtroom, jurors on the left, family and victims of the victims in the back. So I got my first look at Mr. Allen. Had not seen him before. I was quite surprised at how small he is. Just from photos that I'd seen of him back mostly around the time of his initial arrest, I had assumed he's probably somewhere in the 5'10" to 6 foot, you know, stage, and probably a little bit of a beefy man. He has certainly lost weight, and I had expected that, and I knew that. But he's short. He's small, which I did not realize. Hadn't really had that perspective. One of the things that was interesting is at one point, one of the panelists had made a comment that she knew about the case. She'd watched the media, had an opinion about Mr. Allen from watching that, but then seeing him in the courtroom, her opinion has now changed. Essentially, I think what she was getting at was that he seemed very scary and intimidating through the media, but then actually seeing him in person, she didn't get that impression. I really didn't get that impression at all either. He seemed somewhat nervous, although he did calm down as the day went on. But at least initially, wide-eyed and seemed a little bit tense. Seemed to need a little bit of reassurance from the team. He's clean shaven, shaved head. He was wearing a collared shirt that was kind of looked like white with maybe a pink stripe or check or something like that. Give it a little bit of a pinkish hue to it. He was not wearing a jacket or a tie. Mostly spoke with Mr. Baldwin. Can't say he didn't talk to anybody else on the team, but it was primarily Mr. Baldwin who talked to him, and they do seem to have a good relationship. Mr. Baldwin would put his hand on Mr. Allen's shoulder from time to time when they were speaking. Mr. Baldwin is, by contrast, quite a large man, well over 6 feet tall, probably somewhere 6'2" to 6'4". Not fat, but he's got a presence. So quite a contrast between them. I can imagine if I was in a courtroom feeling nervous, feeling intimidated, feeling unsafe, having this sort of large hulking man hovering over me and comforting me and speaking to me, that would make me feel much more safe in the process. Rick was very attentive to his attorneys. He did seem to interact with them. There weren't obvious issues. Obviously, there's, been reports of, mental health concerns and just other things like that. But there was nothing that jumped out as, alarming. He didn't seem like disturbed or anything like that. Seemed to be functional and cooperative, listening attentively, nodding along, participating in the process. Like they would, between rounds, when they would discuss, who's getting stricken and things like that, they would do that as a group on the defense side, and he would participate in that. Also, my first time seeing Mr. McClelland. And I gotta tell you, I realize this is a very shallow first impression, but the dude has coke dealer hair. Okay, it's hard for me to get past. When I say coke dealer hair, what I mean is it's long and slicked back. Not just slicked back, like Mr. Rozzi also wears his hair slicked back, but his is short and faded. So it doesn't the long but slicked back coke dealer look. But anyway, that aside, he was quite effective at his voir dire. In a little bit, I'll go through some of the details of what they did and kind of also give you my thoughts about like how do they rank, skill wise, how did they do? So as was previously announced, no electronics in the courthouse, no drinks, no food, nothing like that. So it's a lot of us in the 3rd floor on the courtroom. There's bathrooms only down on the 1st floor. There's a drinking fountain only down on the 1st floor. And we got one 10-minute break today, guys. One 10-minute break, no lunch. No lunch. We went in session from 9 o'clock to just about 5 o'clock. And yeah, it was quite a long day. I got a little thirsty. I might be sucking on my little water bottle here. Trying to get all rehydrated. But no phones, nothing like that, even allowed in the courthouse at all. So on the one hand, that does make screening us in pretty easy, pretty straightforward. They got us in very quickly. So we started off with Judge Gull explaining what the process was going to look like, what was going on, that the first panel was consisting of 52 jurors. They go in and watch an introductory video and then come up to the courtroom. The first 12 fill in the box. Everybody else sits out in the audience. So the voir dire would take place basically 12 at a time. But everybody else was still there, so they could hear the questions and things like that. Just didn't really participate or have an opportunity to speak up until it was their turn to end up in the box. So then each side got 30 minutes of questioning. The judge has specific questions that she asked the entire panel up at the very beginning, and those mainly went to bias. Those went to things like, have you seen the media? Do you have family in law enforcement? These kinds of basic qualifying types of questions. And then basically every time a new 12 would come into the box, she would just ask them, did you answer affirmatively to any of my initial questions? And then people would say, yes, I seen the media about it. Yes, my brother-in-law is a police officer, things like that. So after her questions, then the attorneys got 30 minutes per side, and they did use that pretty consistently. They used most of their time. They did all of their challenges and strikes up at the bench. And so everything for cause challenges, hardship challenges, medical situations, all of that stuff, it happened up at the bench. We got to see it happen, but we didn't get to hear it and know what was going on in terms of how challenges are being argued, how they are being decided. So it seemed to me like Judge Gohl was not really, I don't want to say she was stingy about hardship challenges, because she wasn't, but she wasn't real over generous with them either. Like, it's clear that for a 6-week trial, 5-week trial, whatever it's going to end up being, November 15th, with the jury being sequestered over there in Delphi, this is a big deal. This is going to make people's lives a little bit more difficult. So a lot of routine kinds of concerns that didn't really get a lot of sympathy. Things like, yes, it's going to be hard for you to get coverage at work. It's going to be hard for you to get childcare. It was difficult, it seemed to me, to get an excuse for those specific reasons. Like, they would have to be quite firm. I got a medical appointment that can't be rescheduled. I don't have any backup for childcare because nobody lives here, family or anything like that would be able to fill in. So that's, I think, part of why those initial 52, so many, it ended up ultimately making it onto the jury. We got many openings. This was a process that the defense had requested and that she granted, to basically, what it says, they give the jury a brief introduction of what the case is about. So Judge Gohl herself reads the instruction, reads the information, the charging document, lays out the charges and the elements of the charges that the jury is going to have to find. But then it went to the attorneys to be able to give a little bit of a fuller picture of what the facts are going to look like in the case. So that gave us a little bit of a preview. So with finding my place in my notes here. So McClelland's mini statement was that the case is about bridge guy, a bullet, and the brutal murder of 3 girls. That seems to me to confirm that this case is kind of as weak as I had thought. The bullet is really the centerpiece, and they're bolstering the bullet with the statements that Mr. Allen ultimately made, implicating himself. So Mr. McClelland described the case that these girls lived in Delphi. They were off school on February the 13th of 2017. It was an unseasonably warm day, so they decided to go out to the Monon High Bridge Trail, which crosses about 60 feet over Deer Creek. It is high. It is a high bridge. you can't, they have it blocked off now so that, I mean, you could hop the little rail fence that they have if you wanted to, but I sure was not going to. God, this place is like scary enough. Even without having to kind of navigate something like that, but seeing it, you know, as a lawyer, it's one of these things that just kind of shocks me that people were ever allowed out there on the first place. I mean, it's a railroad bridge. Like you have the ties, and you know, 6 inches between each one, and that's what people are walking on. You know, all the way across, like 60 feet over the water. There's no rail, nothing. Like it's yeah, if you're not into heights, I'm really not into heights. Yeah, I was not going to look forward to walking across that thing. So he points out, yeah, kids like to cross it. It's kind of a test of their bravery, or maybe it's just fun or something like that. And so Abby and Libby decided to do it that day, but they were not alone. They were followed by a bridge guy. Bridge guy used a gun to kidnap them. He forced them down the hill. According to Mr. McClelland, his intent was to have his way with them, but he was interrupted. So he forced them to cross the river, remove their clothes, and then he cut their throats. According to Mr. McClelland, he then threw the clothes in the creek, went back to his car, but he left behind a clue, this bullet. The bullet was right between the bodies, and the markings show it was cycled through his gun. And from Mr. McClelland, we heard that we will learn from Mr. Allen's own words that he was there at the time. And we'll hear on the video, according to Mr. McClelland, that Mr. Allen is bridge guy. And of course, we'll hear from Mr. Allen that he told his wife, his mother, his therapist, his corrections officers, fellow inmates, that he brutally murdered them, and that he will say why and how, and he will repeat it over and over again. So that was the mini statement that we got from Mr. McClelland. Mr. Baldwin gave the mini opening statement for the defense. And Mr. Baldwin started by saying, Mr. Allen confessed to taking the gun and shooting the girls in the back. But the girls weren't shot. And so he pointed out repeatedly that Mr. Allen admitted facts that were not true. That was really the focus of his opening. He said that Mr. Allen confessed to raping the girls. I'm probably not supposed to say that on YouTube, but oh well. And burying them in a shallow grave. But neither of those things had happened as well. There was no evidence supporting them. So ultimately, the problem here is that Mr. Allen confessed to a crime he didn't commit and relied on facts that were not true. He argues that tons of admissions and confessions are not true, and the context is what was going to be important. Mr. Allen had languished and deteriorated in solitary confinement in Westville Correctional Facility, a prison where the worst of the worst are held. The day before this happened, he was at home with his wife of 30 years and his dog when he was arrested for a crime he didn't commit. And then 15 days before an election, the sheriff sent him to the worst prison in the state and in the worst part of that prison, the solitary confinement. Mr. Baldwin told us we were going to see video of his life in there. This took me back to James, can't remember, Joker guy in the theater. What was his name? Somebody in the chat will remember. Anyway, he had pursued an insanity defense, and some of that was based on James Holmes. Thank you, K. Elf. Thank you, James Holmes. The defense had raised that in part based on video surveillance of his setting. Very similar situation. He was held in solitary confinement for an extended length of time and basically, went nuts. And you can see it. You can see what he's doing in the cell. He's banging his head against the wall, hiding under his covers for 20 hours a day. I mean, just a lot of stuff like that. So I'm expecting this video is not going to be real pleasant. According to Mr. Baldwin, psychologists will tell us that these are the ingredients for a false confession, which is consistent with everything that I know about that situation as well. He talked about soft evidence versus hard evidence and pointed specifically to the bullet. He said that Melissa Oberg is the analyst who has done over 1,100 comparisons. And according to her, she has never been wrong, but she has found fault with others that she has supervised. They've been wrong, but she has not. So Mr. Baldwin was apparently pitching this as kind of soft science, something that's subjective and not necessarily falsifiable or verifiable. He points instead for his example of hard data to the phone. He says there is hard data in the phone. Where were the girls? What were they doing? The state police, again, just flashes to these other cases. There's echoes of Koberger in this. The state police were ill-equipped to understand the phone data, and there was infighting between the FBI and the local police. The local police apparently didn't like the FBI's interpretation of the phone data, and so they just cut them out, just dismissed them. Mr. Baldwin concluded by telling us that Mr. Allen is innocent, and the evidence is going to show that. So all in all, pretty strong counterpoints, I think, on these two opening statements. The weaker answer from Mr. Allen so far, in my view, is still on the firearm, is still on the bullet. He did make the kind of cursory criticism of Ms. Oberg, but really didn't get into the specifics of why this is soft science, quite frankly, if it is science at all, which in my mind is very much in question. That stuff gets real complicated, though. He's going to rely on an expert to explain that, but it's just going to the lack of validation of the types of claims that they're trying to make. Certainly in this particular case, to be able to say that the markings on this bullet allow me to exclude every other firearm in the world as being the source of those markings and identify Mr. Allen's gun as being the only gun in the world that could have produced them. There simply is not a valid scientific foundation to be able to make that type of claim. Yet the state is going to try to make it here. So the panel, like I said, was brought in as a whole. It was not racially diverse, not at all. There were a few black people, but it's mostly white. The ages were very mixed. Really all over the place. I was kind of expecting it to skew older just because most of the time jury summonses do. Part of it, just the pool that they're drawing from, voter registrations, driver's licenses. Okay, maybe there's a good age range with driver's licenses, but voter registration is typically going to skew a little bit older. But then there's also just who's showing up. You know, not everybody who gets a summons is going to show up. One of the ladies from the media outside beforehand was saying that Indiana doesn't pursue contempt for not showing up to a jury summons because they don't, her explanation was because they don't send it certified mail, so they can't prove you actually got it. I don't think most places send it certified mail, and that doesn't preclude them from going forward with contempt. But Be that as it may, even if it's only cultural, apparently they don't necessarily do that. So anyway, I would just generally expect people who are a little bit older to be more inclined to be compliant with it, to show up. People who are younger are going to be the ones that have a harder time getting off work, harder time finding childcare, to allow them to be able to come in. But that really, it didn't seem to happen. There really was a very wide mix of ages. So Judge Gull gave the preliminary instructions in the case. She explained it's going to conclude by November 15th, possibly sooner, according to the lawyers. We're going to start at 9 a.m. In Carroll County and run every day to maybe 5 or 6 p.m., just depending. So they are going to be long days. She explained that they're going to be sequestered, that the bailiff would help them with instructions about how transportation is going to work. They're all going to be bussed over to Delphi. Nobody's going to drive themselves. Assistance with what to pack and so forth. Oh, this was quite interesting. They had to read off their witness lists. Each side read off their witness lists because the jury needed to be, asked if they know any of those people. So I have to say, number one, the acoustics in this room were terrible. They were so bad. It's this wide open, echoey room. And so any little sound, somebody flipping the page on their notebook, somebody coughing, somebody whispering, it would just overwhelm all of the other sound in the room, made it a little bit difficult to hear. But then also in this particular case, when they were reading the witness list, both Mr. McClelland and Mr. Rossi, who read it for the defense, they read it very quickly. So I can't promise these numbers are 100%. They're just in the ballpark. My best count of how many witnesses each of them named. Approximately 53 witnesses named by the state. Approximately 136 witnesses named by the defense. Now, there is some overlap between them. Some of them are the same people, but nevertheless, more than 2 to 1, almost 3 to 1 witnesses from the defense relative to the state. That was pretty astonishing. That's unusual, not the normal state of affairs at all. I don't know if all of these people are ultimately going to be admissible. They did include some names that I recognize, like, for example, Todd Click. Todd Click is the former law enforcement officer who was involved in kind of developing the Odinism theory that law enforcement originally investigated in the case. But the Odinism theory has been excluded by Judge Gull. So if Mr. Click is not going to talk about Odinism, are they going to call him? I don't know. I don't know if there's going to be anything else there. But it is possible that some of these witnesses are just named to kind of preserve the defense's argument that they wanted to call these people, intended to call these people. And so if Judge Gull's ruling ultimately precludes them from doing that, they have made their record that they were attempting to do that. So for appeal purposes, they can argue, here's what this witness would have testified, here's why that witness should have been allowed, and so forth. So we have a live court reporter as well as an audio recording, according to Judge Gull. This matters because I was looking at the Indiana trial rules for how it works in terms of public record. The audio is public record, guys. It's like explicitly there in the statute. It is a court record. It goes, the disc or, whatever they recorded onto goes into the possession of the clerk to be maintained as a public record. That means we should be able to get copies of it. And all these hearings that have happened before, by the way, that 3-day hearing that happened back in August, that I would still like to know a lot more of the specifics about what happened there. That recording, it should be public record. So yeah, why we don't have it, I would sure love to know. It seems like just a little bit more of the shenanigans with the lack of transparency. I had seen that some media outlets had requested to view the exhibits from that hearing. Similarly, the exhibits, these are court records, they are public. It's not even really a gray area is the thing. Like this is pretty black and white public record. Nevertheless, Judge Gohl had advised them she's not going to let them view the exhibits until after the trial. No findings, no order, no nothing, no basis for it that's been articulated. Just that's the way that she wants it done, and it seems pretty contrary to the rules of public disclosure. So this, if you've been following the case, you know this has been an ongoing issue with things. I mean, from day one, the probable cause affidavit is filed under seal. This man is arrested and taken into court and, confined, held in solitary in a prison before he's got lawyers appointed to him. And we're not even allowed to know why until like a month later when it finally got unsealed. Issues with documents being left off the formal court record, the docket, so that nobody even knows that they exist. Yeah, lots and lots of issues with public access. So just so we know, there is an audio. It is supposed to be a public record, meaning that people should be able to get it. If anyone wants to try, I mean, feel free to try. The court reporter being there means that they will also be preparing a transcript, but the court reporter doesn't prepare a transcript for filing until one of the parties orders one from her. So we may get transcripts as part of public record as well, but again, just given the issues that we've had with that in this case, how easily accessible that will be remains to be seen. But it does give me some hope that at least at some point, even if for now in kind of the real time, you're having to rely on me and other people who have been present in the courtroom to kind of tell you about it, that at some point in the future, if not sooner, that original source material itself will be available. So that's good, I guess. She gave an instruction defining reasonable doubt. The defense objected to her instruction because they said that the full instruction it's more expansive, and it is. The defense team read the full jury instruction on reasonable doubt during jury selection a couple of times to the different panels. But Mr. Razi had objected to Judge Gohl's instruction, saying that basically it's not the instruction language is much stricter. So Judge Gohl's definition was that beyond a reasonable doubt, you're convinced beyond a reasonable doubt when you are firmly convinced of the defendant's guilt. That was the standard that she gave. And that if you find there is a real possibility that he's not guilty, then you must vote not guilty. These, are not, from a defense standpoint, these are not particularly great standards. So I understand why the defense then, supplemented that with the entire instruction, because the entire instruction does include a lot more language about how, you must, it's a strict standard, and you don't have to be convinced beyond all doubt, but you must be must be convinced more than just probably the defendant did it. So fleshing out a little bit more than just firmly convinced. But it's very typical for the beyond a reasonable doubt standard to be a big part of the subject in voir dire. The attorneys want to know how the jurors interpret that. What does that mean to them? How can they envision themselves applying it? So that was very much the case here on both sides. No jurors' names were used in open court, just numbers. They are very important about, they're focused on privacy, on keeping the anonymity of the jurors, which is, from my perspective at this stage, extremely appropriate. She advised the jurors they must keep an open mind. They will be able to take notes. They will be able to submit questions, and they may be able to have some discussions about evidence at the break. I found this intriguing as well. The normal rule is that the jurors do not get to talk about the case at all, nothing, until the deliberation starts, meaning the evidence is closed, they've heard the arguments, they're all back there in the jury room now ready to go. But Judge Gold did seem to suggest that there is some limited opportunity for discussions before that happens. So I'm kind of curious to see how that plays out. But also that jurors can submit questions. Juror questions are a can of worms. Let me tell you, some states allow them, some states do not allow them. It's different just depending on where you are. In Washington, where I practice, they are allowed, but they are really strongly discouraged, and most judges don't allow it to happen. I have, however, been through a trial where a judge did allow the jury to ask questions, and I found it a cumbersome proceeding. The way that they did it there was the jurors would write the question on the piece of paper, like any individual juror. You didn't have to go through the foreman or ask as a group or anything like that. Any individual juror could write their question down on a slip, hand it over to the clerk. Clerk would hand it up to the judge. The judge would read it, call defense and prosecutor up to the bench, review it with them, and ask, are there any objections, any concerns, so forth. Problem is, lots of times jurors ask objectionable questions. Like, that's the whole point. They want to know about the thing that has been excluded, or the thing that the witness has been instructed not to answer. And so, you don't get to do that. So then in that situation, the jurors end up not getting an answer to their question in the first place. And I just always worry, are they sitting there like blaming me, thinking I'm trying to keep stuff from them or something like that because we're applying the rules of evidence here. It's tricky, and just depending on how they handle it, that can be more or less of a problem. Because in my case, we handled it up at the bench. The jury really didn't know who, if anybody, was responsible for keeping it out. But it's not against the rule for the judge to say, object. If you don't want me to ask the question, then the jury's going to know who's objecting. I don't like direct jury questions, but nevertheless, looks like they're going to be allowed. So we'll see if that produces anything interesting over the course of the trial. We did have a juror on the panel who professed to be a psychic and was going to be helpful to the prosecution. But that juror ultimately did not make it onto the jury as a whole. Let's talk a little bit about the lawyers and how they handled it. So first off, Mr. McClelland went full alley, like he's running the whole show. There's 3 prosecutors sitting there at the counsel table, but 2 of them, I don't know what they were there for. Wallpaper, apparently, because I really didn't see them do anything. They didn't participate in the voir dire. So everything was handled by Mr. McClelland. Defense was exactly the opposite. They rotated through. They took turns. Mr. Rossi went first. Mr. Baldwin went second. Ms. Auger went third. And then Mr. Rossi finished out the last ones, the last 2 rounds. So we heard more from Mr. Rossi than from either of the other defense lawyers. And we heard more from Mr. McClelland than anybody else at all. My impression of their effectiveness. I gauge effectiveness with jury selection, voir dire, questioning, and stuff like that, very subjectively. And so there's plenty of room for disagreement about this. But I am typically looking at just the cultivation of a connection, the ability to gain the trust of the jury, to be able to kind of captivate them and get their engagement and stuff. So by this standard, here's how I would rate them. Mr. Baldwin, hands down the best. Mr. McClelland is a close second. Mr. Rossi was third. Ms. Auger was fourth. Mr. Baldwin, what I like about him, he simply comes across as an extremely sincere and authentic advocate. He would refer a lot to the jurors to look in your heart, answer from your heart. He would look people directly in the eye, while he was saying this. And so it was just a point, I think, that he emphasized repeatedly, to look deeply, to not just kind of knee-jerk answer, but to really question. He wanted the jurors to really question themselves and consider, is my initial reaction the right one? Or maybe I should rethink that. He was very effective at getting engagement from the jurors. And I do have one objective measurement for why Mr. Baldwin might have been the best lawyer there, was that Mr. McClelland objected repeatedly. So this is also, it's not unheard of during jury selection if somebody is going way out of bounds that you object. But if they're not going way out of bounds, it's just, you just kind of don't, you just don't. Well, Mr. McClelland did, and he did from the outset. So the very first question that Mr. Baldwin asked when he gets up in front of the jurors, he asked them, is it possible Mr. Allen is innocent? God, it was a good question. It's a great question. I love this question. Way to get right to the point and cut to the chase, right? That's the key question. There's such a skill to jury selection and this type of questioning, because you know what you're trying to get, what information you're trying to acquire, but you typically can't just ask the jury outright for that information. You have to ask them things that will allow you to be able to make that inference yourself. You want to know, jurors, can you be unbiased? Jurors, can you be open-minded? Jurors, can you wait until I've had my say too before you make your decision about the case? But the problem is, if you just ask a juror explicitly, Mr. Juror X, can you be unbiased? Of course they're going to say yes. You don't get good information that way. So you have to kind of ask around the fringes to be able to get to that answer that you want. Is it possible Mr. Allen is innocent? I just loved it so much because it froze everybody. It froze me in the courtroom. Everybody stopped and kind of stared at each other. And then Mr. McClelland hopped up. Your Honor, may we approach? So they went up and approached, and he wasn't allowed to ask that question again. Bizarre. I don't know why. I mean, that's the heart of what you're there to find out, isn't it? Can these jurors consider the possibility that he's innocent? Because if they can't, they don't belong on the jury. He's presumed innocent. So that I thought was pretty fascinating, and it did. I think it spoke to Mr. Baldwin's ability to really cut to the chase and make some key points with the jury, that he felt the need to interrupt that, to get in the way of the flow, to maybe not allow that suggestion to be planted, the possibility that Mr. Allen could be innocent. Yeah. Weird how that would be problematic to the prosecutor, isn't it? So, Mr. McClelland, in terms of his demeanor, I did put him as the second most effective. He's clearly done this before, a few times, and he has some skills with it. He's good at being able to react off the cuff, respond, listen to what the jurors have to say, and react to it, not just kind of brush it off or move on to something else or something like that. He was able to build on the questions and turn it into a little bit more of a conversation. That said, now granted, I'm a defense lawyer, obviously, I make no bones about that. So you can infer I might have a little bit of bias in that regard. I'm very upfront about it. My impression of Mr. McClelland is that he came across as a little bit used car salesman. And I say that in the sense that he's overly agreeable, overly eager to like make jokes and smile and laugh and, haha, yeah, my kids are like that too, kind of conversational, yuck, yuck, kind of way of talking to people. It comes across as trying to be likable and persuasive, but not particularly sincere. I didn't necessarily get the sincerity from Mr. McClelland that I got from Mr. Baldwin. And so that's the main reason why I did not consider him to be nearly as strong. Mr. Rossi reminds me of David Yannetti. He reminds me a lot of David Yannetti. They have very similar styles in the sense that they're kind of pugilistic. They strike me as the types who are probably extremely good at cross-examination and maybe not so good at emotionally connecting with the jury. But he certainly did well, had good questions, was able to elicit some good information. And unlike Mr. McClelland, who came across as, I want the jury to like me, Mr. Rossi didn't really seem to care so much. He was happy to challenge people, even people that ultimately ended up on the jury, meaning he accepted them. And so he's clearly comfortable with that. Didn't feel like he needed to make them happy or please them or anything like that. He was comfortable challenging them and still accepting them as decision makers in the case. Ms. Auger looked like the least experienced of all of them. Again, she's probably done it before. She doesn't look like a green, totally green rookie or anything like that. But in terms of that skill I was describing of being able to ask around the question that you're really trying to answer for yourself, she was the weakest at that. She did have a tendency to ask questions that you're just not going to get a good answer to, about how, can you commit to being unbiased? Like nobody is going to say no. I can't do that. So I'll go through my notes and some of the kind of specific things that were asked. Obviously, a lot of folks had hardship issues. He focused a lot on that. He focused on the very common prosecutor question, the CSI question. Has everybody seen CSI? Does anybody expect the case to be like that? Is there any piece of evidence that I'm going to have to show you in order to convince you? DNA, physical evidence, in anything like that. So a lot of focus on kind of prepping the jurors for the weakness of the case, because we know they're not going to have that evidence. They don't have DNA tying Mr. Allen to the scene. They don't appear to have location data and stuff like that. So they're going to be making their case, like I said, primarily built on this bullet, and then they're going to bolster the bullet with those statements that he made. So in some respects, I did think there was a possibility that this line of questioning was maybe counterintuitive, because he was inviting jurors to answer things like what type of evidence would you expect in a murder case? And so people are throwing things out: fingerprints, DNA, alibi, motive, the weapon, all stuff, yeah, I don't think he has. So it's just, you probably maybe didn't want to get them thinking about all of that stuff they want to see before you decline to give it to them. Maybe there would have been a better way to handle that. He, of course, focused on the beyond a reasonable doubt standard. What does that mean to you? He had an example that he would use because he wanted to explore this idea of being firmly convinced and what does that take. So he had a couple examples that he used. The first one was him claiming, "I'm a lawyer. Are you firmly convinced of that?" And then they would go through and talk about why. Well, the judge is allowing you to be here. You ran for prosecuting attorney and you have to have a law license. You're here practicing law in front of us. You've told us you're a lawyer. And so that was enough to firmly convince most of the jurors that he was a lawyer. Mr. Baldwin, he demolished that. It was pretty genius. So it took him to the second round because that's when it was Mr. Baldwin's turn. But Mr. Baldwin had a story from his county about a gentleman who was practicing law who didn't have a license. He had apparently passed. He had gone to law school and he was working for a large name firm, but he didn't pass the bar. So it came out he wasn't in fact a lawyer. And so after Mr. Baldwin had told that story, then more people were kind of willing to be more skeptical. I'm not so firmly convinced that you're a lawyer just because you're here looking like one. Extremely effective undermining of that example, and it made it a little bit more challenging for Mr. McClelland to keep doing it. His other example was you've left on spring break, and when you come home, there's a puddle on the ground. Are you firmly convinced what happened? Most people, no. You see that there's 2 sticks in the puddle. Are you firmly convinced what happened? No. You see there's the puddle, 2 sticks, and 2 pieces of coal. Are you firmly convinced what happened? No. You see there's a puddle, 2 sticks, 2 pieces of coal, and a carrot. Are you firmly convinced what happened? No. There's a scarf. There's a top hat. And finally, there's a frosty name tag. So this line of questioning was basically there to kind of elicit at what point did people make the connection, oh, it's a snowman, you know, it's a snowman and therefore the snowman melted. That's what we're getting at here. Most people got there at the carrot. I had no idea what the hell he was talking about. I gotta tell you, it took me a while. It took me like to the scarf. You know, in part I couldn't hear all that well. I kept being like, is he saying coal? Did he say carrot? So it did take me a minute. But that one too, there were some people that kind of remained a little bit questioning, a little bit skeptical of this example. Like, well, I still don't necessarily know. Like, I don't know the circumstances. I would want to see, like, was there an eyewitness? Is there something on camera somewhere? Was there snow on the ground when I left? So overall, relatively good from a defense standpoint, amount of skepticism from a lot of the jurors that didn't need to be prompted necessarily by the defense. When it was prompted by the defense with the whole story about the unlicensed lawyer, that really, I think, opened a lot more doors. But plenty of people were willing to have those kinds of questions, stay open to those kinds of questions, even without the prompting from the defense. The part of Mr. McClellan's questioning that was probably the most alarming to me is he's asking about credibility and what sorts of things would you look at to judge credibility. And so, this one kills me because you get all the stuff that just makes the hair on the back of my neck stand up. You look at body language, you look at how confident are they, you look at have they repeated the story, you look at are they making eye contact, like all these things that are really, really bad indicators of credibility, right? Because everybody's kind of different, and just the situation is abnormal. People on the stand, unless you're a professional witness, typically aren't going to behave the same way that you would in everyday life. So it's not a good baseline anyway. And you run the risk of drawing bad inferences about somebody just because they're different, or maybe you think they're weird or something like that. This is where Amanda Knox really comes to mind. Police didn't like how she behaved in the period after, like right after her roommate was discovered dead, and ultimately, suspicion landed on her and that whole nightmare that she went through. So that I hated that. But there were at the same time jurors, again, who were like, no, the important thing is consistency. Are the statements consistent, and are they corroborated? Is there other evidence that can back them up? So that certainly gives me hope, because yes, that's pretty much, gonna just say, the only real clue to credibility there is is it substantiated? Is it corroborated? If it's not, guys, it's a toss-up. You trust that person, you don't trust that person. And with people that you know really well, okay, you can have better or worse bases for drawing that type of conclusion. But with a witness you've never met, somebody that is just, again, in this kind of special context, out of the blue, yeah, you don't have that kind of trust to be able to rely on just their say-so. So credibility really, in my mind, depends a lot on substantiation, on corroboration. And fortunately, there were at least a few jurors who indicated that would be important for them. Yeah, the psychic guy was insisting you can just feel their energy. That's how you know. You can just feel their energy. Oof. Questions about why someone would lie. Why would somebody lie? And different thoughts about that. The defense, both parties, Mr. McClellan and the defense, both focused on this question. The defense focused a little bit more on like false confessions, like why? Can you imagine why somebody would do that? What are some reasons why somebody would do that? But that was certainly a topic that came up. And then the state raised concerns about if people were hesitant to pass judgment on another person. This is a kind of common question to ask as well, because there are certain religious affiliations where there's objections. There's strong moral objections to passing judgment like that. Just the view that's not our job. That's it's somebody else's job. So I think trying to flesh some of that out. Weren't very many people who expressed that kind of issue. Plenty of people expressed a kind of personal moral discomfort, like I don't like to judge people. which I appreciate as well. I don't like to judge people either. I like to give people the benefit of the doubt. But that is ultimately the job of the jury. So you got to be able to do that. And certainly at the end of the day, plenty of people were going to be okay with it. At least one of them had this interesting answer of, well, if it's just me, I might feel uncomfortable with it. But when you have a whole consensus, which is obviously what the jury process is about, reaching that unanimous decision, that it would be easier then. So don't necessarily love that from a kind of group psychology standpoint of needing that support, that encouragement and stuff to have a conviction, like not a conviction in the legal sense, a conviction in the kind of moral, epistemological kind of sense. I like independent thinkers on a jury. That's what I'm looking for. As a defense lawyer, I'm looking for people who are open, people I don't like people who make quick decisions and then stick with them. I don't like people who are closed. I don't like people who make snap judgments. I like people that are open, and I like people that are independent thinkers, that are not afraid to go against the grain, go against the group. Because those are your potential holdouts. If you can capture that person and you can convince them and you can connect with them and you can get them seeing the case your way, that person can be a very, very powerful ally in the jury room. So anyway, that particular answer was obviously not that. Not the juror that I particularly was looking for. So Mr. Rossi started off his very first series of questions. He started off with human behavior. Let's talk about human behavior. I'm a Bjork fan. My mind instantly went to, well, you better be ready to get confused. But he had a very good question that was kind of his lead into, which is if somebody had committed a crime, what sort of behavior would you expect to see from them? Just kind of a straightforward inquiry into what does consciousness of guilt look like to you? And so they got a lot of good answers. The person's nervous. They might over-explain. They're not going to act their normal way. They're going to seem different. There's going to be a change in their habits maybe. They might say inconsistent things. They might avoid certain places or certain conversations. They might be paranoid. They might flee. They might destroy evidence or cover up things to try to throw you off the trail. All things that you already know the defense is lining up to be able to show you. Mr. Allen didn't do any of that. He didn't do any of that. He went straight to the police right away to try to help, to give them information. He didn't flee. He didn't hide anything, et cetera, et cetera. So that was a smart move just in terms of priming the jury, getting them already thinking along these lines of this is what guilty people look like, so that when the evidence comes out that that's not how Mr. Allen behaved, then they might be more inclined to think, well, maybe he's not guilty then. Maybe he really is innocent. The defense is very concerned about Mr. Allen's Fifth Amendment privilege, the possibility that he will not testify at trial. They are certainly questioning the jury with that possibility in mind. Obviously, don't know whether he will or not. Sometimes that decision isn't made until the absolute last second. It's ultimately Mr. Allen's decision to make, but he's probably going to follow the advice of his lawyer. Most people typically do, barring particularly disagreeable, high conflict types of clients. Your Darrell Brooks, if Darrell Brooks was not pro se, if Darrell Brooks had a lawyer, would Darrell Brooks be quietly following his lawyer's advice about whether he should testify or not? No, not that guy. But most people who are not that guy don't have that type of high conflict personality. They are going to take your advice. And everything I could see from how Mr. Allen was interacting with his legal team They have a good relationship. They clearly have rapport. He seems to trust them. So I wouldn't expect him to be a big decision maker, obviously, or a big troublemaker. Obviously, you never know what's going on behind the scenes, but just in terms of my impressions, I think it's highly likely that he will follow their advice. A lot of people, answers all over the spectrum with this one. Obviously, there's a lot of people that will always say, if I was innocent, if I hadn't done anything wrong, I would want to say that. I would want to get on the stand and proclaim it. I would want to make sure that the world knew. I would say it over and over and over again. Other people were receptive to the idea of, well, you gotta just do what your lawyer tells you. You gotta trust them. You gotta put your faith in them. They may have their own reasons for making that type of recommendation. I would take their advice. There was really only one person who brought up what, to my mind, is one of the stronger reasons why a person might not get on the stand, is because the prosecutor is going to try to trip you up. You're going to get in a battle of the wits with, this guy over here with many years of education and a lot of practice at asking questions in ways that can be traps, that can put you in a corner that doesn't allow you to really fully give context or give the full answer. Not a lot of people kind of caught that right off the bat. So that is a little bit unfortunate. Mr. Razi would also ask, hey, well, okay, you would really want to hear from the defendant, you really want him to testify. You think if you're innocent that you would want to tell the whole world, you would get on the stand and say that. If the judge tells you you have to disregard, if he chooses not to testify, you can't use that against him. You can't draw any inference from it. Are you going to be able to do that? A lot of people struggled with that. So in a way, it's a good thing, when you have jury selection, to draw that type of thing out. Ultimately, yeah, you just want people to be honest and truthful, because if that is in fact how you feel, then you might not be the right person for the jury. Or, just in terms of, I have strikes that I'm going to exercise. You're probably not going to be my priority to keep on the jury if that's going to be an issue for you. And this is a possible factual scenario at trial. So it's good on the one hand that that people were forthcoming about that, because now we know. Now we can make our decisions accordingly. But at the same time, boy, it's hard to hear. It's hard for me to hear. Just because, I've seen the system from this side, and it sounds so easy, right? It sounds so easy that, well, if you're innocent, you should stand up and fight for it. It's often not that easy. And I'll tell you one of the big reasons why is because almost nobody, we're all humans. Everybody getting on the witness stand is a human. That means by definition, you're not a saint. You're not a saint. And so there's a risk that your warts are going to be pointed out there on the stand to everybody, that all of your flaws, your sins, they're going to be flung at you. And so not only is it this embarrassing, this humiliating, this degrading kind of experience, but it's just, I think for a lot of people, that's going to shake your confidence, because unless you're like some narcissistic psychopath or something like that, you have flaws, and most of us are kind of insecure about them. Most of us don't love having our worst decisions and our biggest mistakes thrown in our face, let alone in front of the entire world. So for me, I really understand why a lot of people, especially in criminal court, are not going to want to testify because they're not saints and there's so much stuff that they're going to have to endure uh, to be able to live out this ideal of fighting for your innocence, getting on the stand and telling your truth and all that. So yeah, that's a little bit of a tough one. They talked about, like I said, why people might say something incriminating. What are some reasons why? Well, the obvious one, well, because he did it. That's certainly a reason why you might say something incriminating. But people did bring up mental health, which was good. People recognize mental health can be a factor for that type of situation. You can just want it to end. Like there were jurors that recognized that yeah, you can break people. You can put pressure on them. You can put them in a situation where they're under duress. That can be like physical pain that they're in, psychological pressure, things like that. So you can just put somebody in a situation where the path of least resistance is to say, okay, yeah, I did it. I'll tell you whatever you want to hear, just to get out of that type of situation. Everyone agreed that we all have a breaking point. So that was good. Nobody was like, I would never. You've never been in that situation, right? So easy to say. Everybody agreed, yes, we all have a breaking point. Mr. Razi had a chart that he would show the jury that he didn't display it to the audience. So I didn't get to read everything on it, but I got the gist of what it is. It was basically the different burdens of proof. So beyond a reasonable doubt, clear and convincing, preponderance of the evidence. He had probable cause and reasonable suspicion on there as well. Those are the criminal standards for a Terry stop and a warrant arrest, things like that. And so he wanted to emphasize is the highest possible burden of proof that you can have. Are people comfortable with that? People think that's appropriate in a criminal case. He did something I thought was pretty interesting. He pointed out that to terminate somebody's parental rights, it's only required to have clear and convincing evidence. It's a lower standard of proof to take somebody's kids away than it is to put them in prison, to take away their liberty, even for something, even if you don't actually go to jail to get a criminal conviction, that's just like a status issue, because now you're a criminal, but you don't necessarily have jail time or probation or anything like that. It's still, beyond a reasonable doubt standard. Some folks, couple folks thought, well, that does seem a little weird. Seems like those should be close to the same. But most people were kind of willing to accept that, well, this is an extremely significant decision. Very important then that it be held to the highest burden of proof possible. Mr. Razi would ask about faith in the government, faith in government processes. If the government has a process for something, does that necessarily mean that it's perfect? Things like Medicaid, things like applying for Social Security, stuff like that. Of course, I don't have the jury questionnaires and the benefit of all of the information that people provide in the questionnaires. I don't even know what the questions are that they're being asked. But I thought that was an effective and interesting way to go, just because so many people, I think, do have experience with those processes. And I'm thinking particularly of some just notoriously challenging ones: Social Security, disability, veterans benefits. Oh boy, if anybody on those panels has gone through those processes, extremely common that, it's bureaucratic, it's time consuming, they demand all kinds of things from you and then lose your application and you have to do it again, and it sits on somebody's desk for months, and then they deny it routinely, forcing you to go through the appeal process to send it up the chain before you can finally get the approval that you're clearly entitled to. This is kind of, from my perspective, fairly normal processing of those types of programs. And so it did make me wonder what kind of information they'd gotten from the jury questionnaires. Like if they knew, do they have a lot of people that have people that are veterans, people that are on disability, people that have relatives that have gone through that process, something like that, because it did seem to be an issue that pretty much everybody was like, yeah, I'd like to trust the government, but doesn't mean I'm going to 100% of the time. The last thing that Mr. Razi brought up was that he wanted to make sure that the jurors were going to be able to focus on what's happening with the evidence, what's happening in the witness box, and the exhibits that are being presented and so forth, and not focused on what's happening in the courtroom. And his issue was, like, for example, if you happen to look over and you see that me and Mr. Allen are conversing about something, and we smile and we laugh, is that going to alarm you? Are you going to be sitting there thinking, this isn't funny? What are you laughing about? Are you going to get mad at me and hold that against me, that I'm coping with gallows humor? So that was just another instance where the answer to that question is not so important. The point of asking it was the priming, to get that into the jury's mind. Don't make snap judgments about stuff like that. Don't hold things like that against people. And that, at least in theory, will benefit the prosecution as well as the defense, because that focus really does need to be on the witness box and what's happening there. The only other things I think I really have to say, Mr. McClelland, his outline was pretty scripted and pretty consistent every time. I did notice, and what I mean by that is he asked about the same topics, asked pretty much the same questions over and over. I did notice that a couple of things, just with kind of style and demeanor a little bit. He was quite masterful at leading and at the kind of finishing your sentence sort of way of putting words in people's mouths, volunteering the answer and getting them to yes. Not so much a inquiry, a drawing out that I saw more from Mr. Baldwin and Mr. Razi. Mr. McClelland did not seem quite as interested in drawing out. He seemed much more interested in implanting. Like, if they already came out with what he wanted to hear, that was great. But if it wasn't, then he would kind of try to get them to where he wanted them to be. So it's certainly a common strategy in jury selection to use it as I don't know what the word I don't want to say propaganda, like that's too strong. I don't want to say mind control, that's too strong, but just to use it to prime people, to try to be suggestive, lead them so that maybe they weren't certain about what their answer was, and you go ahead and give them the answer that you want and get them to accept that. That was overall a pretty common theme in how he addressed them. Mr. McClelland uses his hands a lot while talking. He's a very active, illustrating and this, and it's effective. I have to say it's very effective because it gets your attention. It's not like scripted. It's not routine. It's not like he's got a single movement that he does all the time. He's got a whole variety of them. He really does communicate with his whole body. Underrated skill, really is. So he definitely has that. He gets your attention, and he's able to emphasize things in a visual way that just helps capture more people than, you'll get the visual people, not just the people who are kind of more audio with how they think and how they process. Yeah, so Mr. Baldwin, I talked about how he would use a lot, do you believe in your heart, look in your heart. He really had that sincere, emotional type of approach with the jury. He wanted to connect on that heart level. I found that very effective. Is it possible the defendant is innocent? Oof. Oh boy, yeah. Mr. McClellan didn't like that. He didn't like that at all. So he did object, and Mr. Baldwin was clearly not allowed to go down that road. He did a lot with a lot of focus on the part of the standard that probably guilty isn't enough, and this I think was pretty effective. Not just by reading out the standard, but then kind of playing it out a little bit. Giving them examples. You think he's probably a lawyer, but do you really know? Are you really certain? He was really able to turn that "Are you a lawyer" example of Mr. McClellan's. He was really able to flip the script and turn it to his benefit. I thought it's a strict and heavy burden. It must be a fair, actual, and logical doubt based on reason and common sense. You may not convince based on suspicion or speculation, and probably guilty is not enough. So a lot more than just the firmly convinced that Judge Gohl had given them in the instructions, and that Mr. McClellan focused on when he talked about beyond a reasonable doubt. It was during his questioning where the juror volunteered. I had this opinion about Mr. Allen, and then when he came in, I saw something completely different, and it changed my mind. So now I'm more open to that. So I think the fact that that was volunteered, he didn't have to draw that out of this particular juror. I do think that spoke to his sincerity, and the jurors, that juror, I think, responded to it and volunteered this bit of information that, if you walk in and you think the guy is guilty and this is his advocate, you're not necessarily gonna be helpful to that person, or want to connect with them. And so I think, at least in part, that answer and that mind shift can be somewhat attributed to Mr. Baldwin and his approach to the questioning and jury selection. He made it very clear to the jury that they will be very critical of law enforcement, but respectful. Respectfully, but forcefully. They will be challenging. So he wanted, he wanted to know if anybody was going to have an issue with that. Again, a situation where you're probably not really looking for an answer, because who's going to say, yes, I have a problem with you challenging law enforcement? Most people, even if that's true, they aren't going to tell you that. So it's really there just to give them a heads up. This is what you're going to see in the case. You're going to see us challenging law enforcement very hard. He had an interesting kind of self-categorization exercise that he had the jurors go through that I loved. If I pick a jury again, I might steal this one. I really liked it. He talked about, when you get in a group setting, you're naturally going to have some people that are going to lead, they're going to speak up, they're going to want to assert their opinion, and they've got their opinion, they want to share it, they want to bring others over onto their side. Other people who are more listeners, they aren't necessarily going to walk in with a firm opinion, they aren't necessarily going to want to persuade anybody of any particular thing. They're going to want to hear everybody's point of view and then come to a conclusion at the end of it. So we asked everybody to categorize. Who are you? Are you an opinion? Are you a person with an opinion, or are you a listener? Most people characterize themselves as listeners, but there are people who will say, yeah, I'm going to have an opinion. And that's such a helpful thing from the defense standpoint for those reasons I said before. You want people. You don't want people who make snap decisions, but you definitely want people with strong decisions and people who aren't going to be afraid to stand by their decisions even if they aren't popular, because those are your potential holdouts. Those are the ones that are not going to be able to be bullied into going along with the verdict just to get the process over with. Which I've always, kind of as an aside, thought like, that would have tied in well with that false confession stuff, wouldn't it? You do it to get it over with, get it done. You ever think it might be like that back there in that jury room? What do you think you're gonna do in that situation? Are you gonna fight for justice at all costs, or are you gonna decide, no, my wife is sick and I haven't been home for 6 weeks and it's my grandkid's birthday and I'd really like to get out of here? Just a possible little link there. Maybe the jurors will make it in their own minds. Incidentally, Mr. McClelland also objected to this categorization, but the jurors were allowed to go ahead and do that. He asked them to characterize themselves as whether they are a little bit more logical or more emotional in their decision making. More easily influenced by emotions and things like that. He's clearly concerned about the fact that this is going to be an emotional trial. This is a horrifying crime. There's going to be testimony from victims, from families. They're going to be upset, probably going to be lots of tears. They're going to see stuff in the exhibits that is really unpleasant, that they're not going to want to see, that's going to probably cause some pretty strong emotions. So he wants to see who is going to be particularly affected by that, because those people, maybe this is not the right trial for them. The defense asked a lot about experts. All of them did this. It started with Mr. Baldwin, but they all asked about experts and kind of to what extent would you defer to an expert, and what sorts of things do you look at to evaluate, should I rely on this expert or not? Again, some people will be deferential. Some people are more, well, I'll evaluate it based on kind of the totality of everything and what are their credentials and is it consistent with my own life experience and common sense. Jennifer OJ used an example. She held up a book. It's like a law book. It's dark blue, like a really dark navy blue, and says, if a highly qualified expert gets on the stand and tells you that this book is red, what do you do? And I think that can be a helpful analogy. It's a little oversimplified, obviously, because most of the time, obviously you don't need an expert to tell you the color of the book, because we can all figure it out for ourselves. We have enough life experience, so forth, to be able to make that judgment. The things that experts are allowed to testify, their opinions about, are by definition things that are outside of the ordinary knowledge and experience of lay people. So it's highly specialized expertise by education, training, experience, and so forth. Something unique that the jurors aren't in a position potentially to be able to independently evaluate for themselves. So in that sense, like, it's not super on point as an example, but it's certainly helpful from the priming standpoint. Be skeptical of the experts. Just because they say something, it doesn't mean that it's true. You have permission to question them. You have permission to disagree with them. You have permission to think that they're wrong. So to that extent, that was also quite effective. He asked if the jurors were going to be able to wait. He said, "We have a story to tell. We have a story to tell." 136 witnesses or whatever it was, yeah, they do. They definitely have a story to tell. This is not going to be a sit back and, you know, try to snipe at the state's case. Although one of the jurors did say, well, I'd better wait because he's going to go, but then you're going to come poke holes in all of it. I like how you think, juror. They are, but nevertheless, having a story to tell, not just through the criticizing of the state's evidence, that was a commitment that I got from Mr. Baldwin through that question. So we are going to get a defense case. This is not going to be a purely defensive, build the case on reasonable doubt, you can't really know, you know, types of situation. They're going to tell us a story. See if I got anything else in here that's worth highlighting. Yeah, Mr. McClellan really just did the same thing, the same types of questions the whole time. Mr. Auger, or Ms. Auger, like I said, my view, the least effective, just because she asked the question she wants the answer to, which sounds funny, but it's just not effective because you're not going to get good answers. And I made a note of the last question that she asked. I have a little note. This is a terrible question. Can you wait with an open, unbiased mind? I mean, if people could know that and people could reliably tell you that, maybe it would be a helpful question to ask. But it's just not, you know. Everybody thinks they can be unbiased. Everybody thinks they can be open-minded, and you've just kind of suggested something to them that they're not. Most people are not going to argue with that. Now, I will say there were people who flat out, I'm biased, not changing my mind. And frankly, I commend them, you know, for being honest about that, for being open about that. That doesn't necessarily mean they've decided he's guilty, too, I gotta say. I mean, there can certainly be people who are like, yeah, I followed this whole case and I don't think he did it and I'm not changing my mind. It's not like this is a question or a position that just favors one side. So I do think that that's helpful to bear in mind when they're talking about bias. Bias is not a one-sided issue, but that's ultimately what you're trying to get at. It's just not helpful to ask somebody directly because you're not going to get a good answer. Let's see. Lots of people, most of the people that didn't want to do it for hardship reasons, you know, were fairly emphatic about not having childcare, not having transportation. It's going to be a massive financial burden. I did learn that in the state of Indiana, jurors get paid $80 a day for the first day of jury service, and after the first week, it's $90 a day. So that's a lot better than the, I believe, $10 that they still get in Washington. Something absolutely ridiculous like that doesn't even buy you lunch. But it's still clearly not a fortune. One of the jurors who had a hardship, you know, claim, was able to say, knew off the top of her head, well, I make $230 every day. So yes, this would still be a major pay cut, and that would cause me a significant financial hardship. So clearly better than nothing, but still works out to what? Not quite $3,000 a month, something like that. 27 days. Yeah, and 27 days is not even, that's not even the month, because it's 20, 5 work days, 20 days. It's not a lot of money. It's just not a lot of money. And until legislatures decide they want to pay for it, that's going to be an ongoing problem. People can't get away from work and drop their lives and not be able to pay their bills in order to do their civic duty. As great an aspiration as it is, it's just not feasible. So yeah, by the time Mr. McClellan was doing his last questioning, people had just all kinds of ideas about the evidence they wanted to see in the case that they're not going to. People are no longer as firmly convinced that he's a lawyer just because he's there in court, saying that he's a lawyer, apparently acting as a lawyer. One lady who says, if I'm hiring you, I want to see some paper. So maybe if it's just casual, she'd be okay with it. But when she's got to rely on it for her own interests, depending on it, then she wants that corroboration. Not very many prospective jurors who had prior jury service. One man had been on 3 prior juries, but it was all a long time ago. They were all criminal, 2 convictions, 1 acquittal. One gentleman that had been on a criminal jury and convicted, and then a couple people who had been on civil juries, which nobody really followed up on the outcome because they didn't care because it's civil. But they did ask about the process. Did you like it? Was it generally positive? Was it difficult? The man who had been on the jury in an assault charge and had convicted reported it was difficult. It was not an easy decision. They were at it for quite a long time. I wouldn't say he was like super distressed about it, but you could see, I felt like you could see it was not something he enjoyed reliving that memory. It wasn't a particularly pleasant memory for him, but clearly they did get through it and reached an outcome of guilty. Mr. Rozzi, he kind of concluded, he took the final shot at the analogies that Mr. McClellan was using by saying, is it really important if it was a snowman or not? Is it really analogous? Is it really analogous to the decision you're being asked to make in this case? Mr. McClellan didn't like that. He objected to that as well. But Mr. Rozzi was allowed to continue this line of questioning. And so he just drew out that because this is a more significant decision, it's a more important decision for a lot of reasons. It's that much more important to be careful and to not just, you can't just make a snap judgment casually based on inferences and assumptions and things like that, that it's far more important to be careful. So good priming there from a reasonable doubt standpoint. During the last full panel, there was an individual who had been to prison. And so that was pretty interesting, just because it's fairly novel experience. It's getting more common, like back in the day when a prison sentence meant a felony conviction, and a felony conviction meant you're disenfranchised and it's a whole process and pain to get your rights back. You didn't see a lot of people on jurors who had been to prison. But a lot of places have made, I guess re-enfranchisement is probably the right word, restoration of rights, a lot more easy, more automatic. Sometimes when you're no longer in prison, sometimes when you're no longer on probation, sometimes when a certain amount of time has gone by afterwards, then you'll automatically be reinstated. And so it's going to start being more common. But I haven't had that happen in a jury panel. So it was interesting to see how the lawyers fleshed out that experience and tried to develop it and see how it could be helpful for their side or not helpful for their side. So they drew out things like the prison environment. In that particular respect, the juror was not really helpful to the defense, was of the position that, you know, it's not really that bad, but it just kind of depends on what sort of criminal you are. Are you somebody that is going to learn to accept your situation, put your head down and go along with it? Are you going to fight it and make it worse? So that was kind of an interesting insight. I'm sure that the defense was hopeful that, oh, this is somebody who's going to understand. Yeah, there's bad guards, and they'll do, you know, they'll do some terrible things in there and stuff like that. Bad environment, lots of violence, scary, all that type of thing. Did not get that from the juror who had been in prison. A lot of people, however, did feel that, you know, they talked about prison and what it's for. And this was subtle and sly, because the defense is going to be making the argument he didn't belong there. He hasn't been convicted of anything. He has no criminal history. That's part of the point, is the effect that would have on somebody who hasn't already gone through this whole process and been convicted. It's going to be, I mean, culture shock is an understatement. You know, the description they gave, one day he's at home with his wife of 30 years and his dog, and the next day he's in solitary confinement in the worst prison in the state with the worst of the worst people. Yeah, that's not anything like the same experience that somebody who has committed a crime, gone through the process, been convicted, and finds themselves in jail. What kind of effect is that going to have on them? But a lot of people did express the view that prison is not particularly effective, that it can even be counter effective. It should be more for rehabilitation than it is. The prospective juror who had been to prison before was of the opinion that it can be used for whatever the person who has the keys wants to use it for, which is probably one of the most truthful things that was said. It's power. Yeah, that person has power. They can use it for whatever they want. That's it, guys. That's my notes. Here's didn't get quite all the way through one legal pad, but most of the way through one legal pad. I actually almost ran out of ink today. I brought two pens, but I almost ran out of ink, so I'll be bringing extra pens tomorrow. So, like I said, we have 14 of 16 already selected. There was a second panel of 50-ish people. The way it works is they come in, they have to watch a video. It's usually just an introductory kind of, this is where things are in the courthouse and who the people are and that type of thing. So apparently what had happened, they had brought in a panel of 52 for the morning, brought in a panel of 52 for the afternoon, but we never got to the people that were there for the afternoon. It took the entire day to deal with the morning panel of 52, which, when I think about the math, like, they should have known that, right? You have five rounds of 12. The lawyers are getting 30 minutes each. So it's an hour per, plus then the time that Judge Gull is asking her questions, then the time it takes to go through and do the strikes and the challenges and stuff, which, incidentally, it was long. And it was also a little bit obscure. I talked with Lawyer Lee kind of briefly about how on earth are they doing this, because normally you handle cause challenges first, and you handle hardship types of challenges first. Because then that's how else do you know who you need to exercise your peremptory on? You know, if I'm going to exercise a peremptory on somebody who is stricken for cause, what do I do now? What's my backup plan? They only had, so each side had their one piece of paper that they would make their notations on. Judge Gold would call them up to the bench. They would confer at the bench with their papers, but all the decisions are being made, there. So it's just, it was a strange process. It was not at all clear to me, how they were working that out. But nevertheless, got through it. 14 people out of the 52. So anyway, what I was saying is it's like 5 hours minimum, right? Just to get through the 52. Then you add in all the other time, and it's easily, adding up to what it ultimately was, which was over 7, 8-ish. So what she did is she decided that 52 that had been waiting all afternoon, she was just going to release them. They're done. They don't have to come back. The people that were already originally scheduled to come in tomorrow morning, those 52 will come in, they'll watch the video, and then they'll go through, same thing, seat the first 12. Pretty good likelihood, just at the rate of how people were being excused, how people were being challenged and stuff, they're going to be done probably with that first bit of that first panel tomorrow. They only have 2 peremptory challenges each for 4 alternates. Of course, I don't know how many they've used so far, but it's their options are limited. So like, unless the entire panel is getting stricken for cause or for hardship or something, then that first group of 12 is likely going to get the final 2 people. So it shouldn't take super long, couple hours tomorrow morning. Here's what I'm expecting timeline wise. I think we're going to go in, we'll start at about 9, like we did today, maybe a little bit later, 9:15, 9:30, whatever. They'll get the initial, they'll get the jury set. They'll get those final 2 alternates selected. And then we'll probably take a little recess. Doubt it will be a long one. And then we're going to come back and deal with the outstanding motions and any types of logistical issues. So again, the motions we're still dealing with. A couple of the motions in limine. The defense expert, I know, is still on the table. The issue about who's going to be able to sit in subject, to be exempt from the exclusion order, whether the state is going to get to have 2 people, whether the defense is going to be allowed to have their intern who's helped them manage, organize the exhibits, the digital presentations and stuff like that, the media that's going to be shown in court. They want that person to be able to sit in as well. Should be allowed to do that, but we'll need to get rulings on that. And otherwise, I think that's about it. Were there any other motions? Don't think so. So, as the jury was excused at the end of the day, and the judge is kind of wrapping up. And as she's wrapping up, some of the folks in the media are getting up to go. It's like 4:30 by now, so I'm sure people are getting ready for their, their 5 o'clock news segment or whatever. Judge Gold did not like that at all. She snapped out. We're still working in here. So I would beg your indulgence. It was passive aggressive, but not necessarily so passive. She does not like the media, guys. She does not like the media one bit. She then indicated that one of the individual jurors that's already been selected has presented some issues. That was it. Don't know what the details are, but they're going to have to deal with that. Does that mean we're already using an alternate? Does that mean we'll select another one? I don't know. But she said it. There's already an issue with an individual juror who's been selected, so we're going to have to be dealing with that. Scheduling wise, here's what it looks like then. So tomorrow, Tuesday, We'll get the jury selected. We'll get the outstanding motions dealt with. Wednesday will be a day off. Wasn't anticipated. Thursday is the day that Judge Gohl had selected for transportation. There's apparently an issue with, just coordinating and how are we going to be able to get that done? And it just came down to she was going to have to pick a day to do it and set it. They couldn't just like play it by ear and wing it depending on what happens. So she picked Thursday, which, was a pretty good guess. Turns out now in hindsight, maybe it could have been Wednesday, but of course, if she had picked Wednesday, then we would have had all kinds of problems with the jurors and they wouldn't have been selected yet. So at this point, Wednesday will be a day off. Thursday, the plan is they will bring the jurors in for the sole purpose of swearing them in, because that has to be done in Mr. Allen's presence in open court. But then that's all they will do as far as business of the court. So they will then load them on the bus and transport them over to Delphi. I don't plan on being in court for the swearing in. It's not critical. We'll get to see, of course, who the jurors are, like in their configuration in the jury seats. And based on that, once I see them all seated, I can probably go back and go back over my notes and kind of get a little bit more information about how some of them answered some of the questions. So that will be Thursday. So for my purposes, Wednesday and Thursday are essentially both going to be days off. And then Friday is when they will start the openings and the state's case. So Friday will be in Carroll County over there in Delphi, and I'm expecting that to be a very different scene in terms of both just the amount of room in the courthouse that's going to be available. I don't think there's probably going to be 25 seats for media in public. I don't know, but I just am skeptical. But also the volume of people that are showing up. Openings are big. Openings are popular for a good reason. I mean, they're telling us what we can expect, what's going to happen over the next 6 weeks. And then the rest is, filler detail. It's just the taking of the evidence, the fulfilling those commitments that the attorneys made to us in the opening statement. So I expect interest in that is going to be extremely high. So I'm going to be there very, 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 very early. Very early. I hope it's not too cold. If it is, I'll be prepared. So that's it, guys. That's where we're at. That was the day. I see there's been a number of questions that came in. So let me go ahead and check that out. Pardon my terrible angle here. Like I said, I'm not in my normal studio and I'm just making it work with what we got. But so it's a little bit challenging to see my laptop here. Skeptic Curiosity is a member. Welcome. Thank you so much for joining, as is Cook13 Doodle. Cookie. Welcome, Cookie. Glad to have you here. Lana, Truth and Transparency. Thank you so much for the super chat for the lunch we didn't get. Yes. Fair enough. Fair enough. We got a 10-minute break in 8 hours. I will say I don't expect Judge Gohl to be courteous to us, the public, the media, so forth. But I'm honestly shocked she was not more considerate of her staff. Like usually, in my experience, judges are hyper protective of the breaks for their court reporters, their clerks, their bailiffs, and so forth. Judge was particularly good at this. Would constantly kind of check in on how everybody was doing. Judge has karate over there in the Delphi Heard trial as well. Judge Gohl, that didn't seem to be a big issue for her. Now, of course, I don't know, her relationship with her court reporter could be that they're on the same page, like let's just bang it out, get it done. I don't know. But no, we didn't get lunch today, so thank you very much for that, Lana. Pudding Man didn't do nothing wrong. It was odontologist. Says he will be free. May he breathe life into us all. Hallelujah. Thank you, Pudding Man. Let's just hope for the best in that situation. Salty Beach girl Lori, just a thank you for this huge commitment. Well, thank you. I feel fortunate that I'm able to do this, that I'm able to go to trials that I find extremely interesting and extremely important, and yeah, be able to take the time and to travel over here. Your support has been critical for that. It means a lot to me. So thank you all very much again. And thank you, Salty Beach girl Lori, as well. DK, say all the words you need to. Appreciate you. Well, thank you. It can be a lot of words sometimes. I can have a lot of thoughts about things. Jury selection, it's just such an art. It really is such an art. I'm sure there's science to it too, and there's certainly technique to it, but so much of it is just intuitive. I did get the impression I have like an affinity now with Mr. Baldwin. Just having seen everybody in court, how they present and everything like that. I do feel an affinity for Mr. Baldwin, and I am more forgiving now of that Frank's memo. That was a little bit hard on. Didn't love the tone. Didn't really think it was presented in a way that was doing Mr. Allen a lot of favors. Felt that it could have been presented in a manner. It was always going to be low odds for that motion to be granted, but just it could have been presented in a way that I felt could improve that. Instead of like really criticizing the law enforcement and pointing out all of the questions that they should have asked and how they fell down on the investigation and so forth, pointing out the decision whether or not to issue a warrant, it's based on a probable cause standard, and probable cause is a totality of the circumstances test. It's not supposed to be we're cherry picking the information that we think that you need to know, that if you only know this, you'll think, yeah, this guy probably did it. But if you see the whole totality of the circumstances, you might have more questions about whether that's a reasonable inference or not. So just it could have been a little bit more dispassionate and a little bit more tailored to the specific legal standard that's at issue in Frank's. But having said that, I really like how he presents to the jury. I feel like he's the type of lawyer that's how I kind of always tried to be in trial, which is you just have to be sincere, because the jury, they can smell bullshit from a mile away. And so if you're trying to sell them something that you don't personally believe, they're going to know. They're going to pick up on that. They're going to spot it. They're going to realize you don't even believe this, but you want me to believe it. And then you've lost them. You've lost trust. You've lost their ear. You're not going to get anywhere. So that can be one of the challenges of being a criminal defense attorney, taking a case to trial, a hard case, a case where maybe you didn't recommend it to go to trial, but your client really wants to, so you got a job to do. It can be hard to find what is that core part of the case that I can really connect with and resonate with and truly believe, that I can sell to the jury that's not bullshit. And sometimes it's as simple as, ladies and gentlemen, this is the most important decision that you will ever make in Mr. XYZ's life. I beg you to be careful and to hold the state to the strictest burden of proof beyond a reasonable doubt, and sit your butt down. Because if you actually go through the details of like the evidence and what came out and stuff like that, might not be so helpful. But you have to find that core thing that you believe in. And so Mr. Baldwin, I get that feel from him, that is his style as well. He's a sincere lawyer. He's not there to bullshit the jury. And he wouldn't be very good at it if he tried. Like, it would be transparent. So to me, that's significant then, that he is advocating very explicitly, Mr. Allen is innocent. He's innocent. I think he truly believes that. So we'll see, we'll see how things unfold. We'll see if that sincerity continues to hold up. But that is very much my read on it. So anyway, thank you, DK. There's some more words for you. Senior Tiny Baby Goats, thank you very much for your expertise and experience. Well, thank you so much for the support. Thank you for the super chat. Thank you for being here. Nicola Maxwell is here as a member. Good to see you, Nicola. Thank you so much for joining. DK is a YouTube member as well. Thank you so much, D. Appreciate your support. Jeremy Morton, thank you so much for your work. I feel like there is more than one railroad track involved here, metaphorically. Yeah. Yes, this case, so many twists and turns, and just so many levels to it. One of the challenges that I had when I started to dig into it, especially with the third party suspect stuff, is like, which one? There's so many people that there's at least, I mean, from my perspective, what I know from the pretrial stuff, at least as much evidence against them as there is against Mr. Allen. At least as much. You have confessions. You have lies, blown alibis, lies about alibis, changed stories. Distancing, I didn't know her, I never met her, changed to I met her one time, I barely knew her. Yeah, a lot of that stuff. Different reasons to think different people could be involved. The Anthony Schatz, it was one of the, this is Keegan Kline, who's on the defense witness list. Was convicted of child exploitation, was communicating with minors online, and had been in communication with Libby, I think, the day before. So just all of these strange angles, strange directions, and then just before you even get into the rabbit hole of the Odinism and, are corrections officers involved in this? Sounds like they are, because according to the memo, at least one has like a face tattoo, an Odinist face tattoo, working as a prison guard. Ugh. All kinds of twists and turns and complicated questions. Stephanie, thanks for your hard work. How did RA look? Like I said, initially, he looked wide-eyed. He looked nervous. He looked scared. But as the day went on, he did seem to calm down and get more comfortable. He spoke with like I said, Mr. Baldwin is the only person I saw speaking with him. I can't say he didn't talk to anybody else on the team. But I certainly saw lots of interaction with Mr. Baldwin multiple times. They look very comfortable together. There was one point towards the end of the day when everybody had left counsel table. Like, they just ended up in different places. I think Rozzy and Baldwin were up at the bench, and Ms. Auger was, I think, talking to the intern. So he's sitting by himself there at counsel table. And he did look lost. He looked anxious. He was looking around like, where is everybody? Are you coming back? He did not look comfortable sitting there by himself. So I do think he gets a lot of comfort from his team. That said, he generally looked healthy. He's lost weight, since his mugshot, no question about that. But he didn't look, he didn't look gaunt. He didn't look starved, nothing like that. And he appeared to be, coherent, functional. He wasn't like, nothing strange, no peculiar behavior, nothing indicative of, florid psychosis or anything like that. So, by and large, he seemed pretty good. Trying to think if I just saw a couple brief expressions from him. He would look out at the gallery a couple times, but didn't really like react, didn't really have expressions that he made or anything. He seemed almost distant, almost like separated from it. Which I mean, I can understand, I think, being in that position, and it probably hasn't settled in yet, the process and what that's all going to entail with, I mean, I know he's been in court several times already, but just being there with all the evidence being presented, all of these people scrutinizing, and it's all about him, the focus is on him. I don't think he's comfortable with that. Just the impression that I got. Be Frank, thank you for the unbiased report. Well, you're very welcome. I don't ever profess to be completely unbiased because no human being is, and certainly what I share as far as my analysis, my thoughts, my read on things is very much colored by my background and experience on the criminal defense side. But when it comes to reporting what happened in the court, what happened either happened or it didn't. The facts are the facts. And so that's the most important thing. It's the main reason why I'm trying to be there in that courtroom, is just to make sure we're getting reports of the facts. We're getting reports of the facts from people that understand them, know what the significance is. And so we're able to then be able to draw good inferences from that, and not have to, go through a whole process of trying to sort out, well, this was reported, but it doesn't make sense. What does it even mean? This is the problem that I've had with legal journalism for decades now, is just when it's being reported by folks that don't have the legal background, there's often misunderstandings, or things that are wrong, things that are misunderstood, or just things that are significant that they don't necessarily understand or appreciate that. So it's just not reported in a way that's helpful for me as somebody that's trying to analyze the process, from the perspective of somebody who's participated in it before. So I do very much try to be unbiased when it comes to reporting the facts of what happened. When it comes to my opinion, like everybody else, I'm a human, I have a background, and you can take it or not with however many grains of salt you care for. Cargo Pilot Guy, you should make a book suggestion video one day. Oh man, that would be a long video. I have so many books that I love. Off the top of my head, you want a book suggestion? I'll give you one. It's just been on my mind because every time I leave the West and come somewhere else, especially like seeing Deer Creek, all this water around the Wabash, I suppose because they have the canal system here, it's a little bit more like the West. The West, we are so arid. Our water is all engineered. We are based on dams. Flood control and irrigation are our key. I don't think they irrigate here. I don't think you need to irrigate here. You would not be able to grow anything where I am without irrigation. So I offer this by way of background because the book that I have in mind that I recommend, Cadillac Desert, A History of Water in the American West. It sounds like one of the most boring things that you could ever read, but it's fascinating. It's written so well. It's written like a story. I just really enjoyed it. I like nonfiction in general. There's plenty of fiction I like too, but I just really enjoy nonfiction. That's one of my favorite books. My only complaint is that it's a little bit dated now. It goes up to like maybe the mid-1980s. But it's just a fascinating story. Wars between the Bureau of Reclamation and the Army Corps of Engineers over dam building, and it's this territorial, government stuff, and California and the stealing the water from the Owens Lake Basin, and I found it fascinating. So anyway, That's my book recommendation for today. Just apropos of nothing. 20th Century Fox, do you know where he is being held? Better Place. Yes, he is in the local jail now, and I can't remember which county it is. It's not Allen. It's not Carroll. I would have to look up. But yeah, he is no longer in prison. That was about a month or so ago. The defense had asked to reconsider the safekeeping order that had had him there in the prison. And this time it was granted. Maybe it is Allen County that he's in. I just can't remember now off the top of my head. But there was a jail, a local jail that was willing to take him, and so he was transferred into a local jail, which is just a much more appropriate setting, you know, for somebody that is being detained pre-trial than solitary confinement in prison. Dennis Jensen, thank you for taking time out of your calendar to cover this case. Based on your introduction to the case, it seems to deserve proper coverage. Well, I definitely think so. I mean, the problem is that if you care about justice for the girls, it doesn't achieve that to scapegoat somebody, to just pick somebody to sacrifice to the mob for the purpose of saying, hey, we got somebody because you didn't get the right guy. It's important, so critically important, to be sure that we got the right guy. That's what makes it justice. That's what makes it justice. So there's just enough questions about this one and enough problems with the process, enough reasons to be concerned with how it's unfolded and whether it has treated him fairly, whether it was even really ever intended to treat him fairly, that makes it such an extremely important case to me. And I say that just because so many things in how this case was handled. I mean, from the very beginning, arresting him and sealing the probable cause affidavit, so nobody even gets to know, meaning nobody will be asking any questions in those early days. He's not appointed counsel for several weeks. Now, I can give a little bit of a pass on this because initially he thought he was going to hire counsel, so I can put a little bit of a pass on that. But sending him, signing this safekeeping order and sending him into the prison to be held before he's had a lawyer involved in that whole consideration, litigation of it, I don't like that at all. There's really nothing but bare assertion that he's not going to be safe. We can't keep him safe. Nobody wants somebody to be in a setting where they're in danger. And so it's a legitimate concern. The problem is just concerns need to be based on facts. I can't just take somebody's word for it. I can't take their conclusion for it and assume that it's good unless I know what that conclusion is based on. So why would it be unsafe? Why can you not keep him safe? Are you telling me you don't have enough guards? Are you telling me you don't have a solo cell you can keep him in? Are you telling me you can't keep him under observation? I mean, I need more than just, it's outside of our pay grade. So not having an attorney involved in that, really troubling to me, particularly given the impacts that we've seen that it's had on him, and because of that, on how the case is unfolded and the prospect for actual justice in this case. Had they not done that, had he not been held in that solitary confinement, say it's a virtual certainty, we would not have any of those confessions. We wouldn't have them, because that's what brought them about, was that context. And so without those confessions, now we're just back to there's a bullet, and that's the case. We don't have these statements that he made to bolster them. We just have this bullet, and that's the case. And that's alarming, because that is tissue thin. That is tissue thin. Chris A is gifted 5 memberships. Thank you so much for that. Thank you on behalf of everybody who went green because of you. Patrick McKernan, why not hold it in Indy? Thanks. I'm not sure. I mean, so I know that they wanted to hold the trial in Carroll County just for ease of the witnesses, the prosecution, the evidence, the law enforcement. If they do end up having a site visit, which I'm not convinced that Judge Gull is going to allow, but we'll probably find out about that tomorrow too. That's another pending motion I'd forgotten about. The defense has asked to allow the jury to view the scene where all these different things occurred. Having been out there myself now, I am very much in favor of this. I think it's really important. I did not have a real clear perception. I thought this place was very remote. I thought it was very remote. So not really that surprising that somebody is out there walking around alone. They might not bump into a lot of people. It might be easy to, get them isolated, get them redirected. But when I actually went out there, it's really not. Like the whole trail out to the bridge, maybe half a mile. It's not very far from the parking lot. There's houses a good half of the way down the trail. Big farmhouse, like is the last house. You can not quite see it from the edge of the bridge, but it's not far. You can hear traffic. You can hear traffic noise from the road nearby. It's just not at all what I had envisioned. And so it changes my perspective on the crime, how it happened, that it happened during the day, apparently during broad daylight. Well, broad daylight, it is February and it's getting late in the afternoon, so maybe it's duskish. But the girls were supposed to be out by 3, so it's still daytime. Yeah, it just changes my perspective on it because the risk is so much higher. If it's a situation where wouldn't really be that surprising if somebody else was walking around out there. It wouldn't have been hard if one of the girls had screamed or something for somebody in one of the houses to hear it. If they were able to get away, able to run, don't necessarily have that far to go. So it changes the dynamics of the situation quite a lot to me to be there and see it with my own eyes. So I do hope the jury gets that opportunity since they're not local. They're being pulled from the different county. So as far as the location itself, I think it's mainly convenience is why they're holding it in Delphi, and then pulling the jury from Allen County and transporting them over. Again, I don't know why Allen County specifically either. Possibly that because of what I mentioned before, it seemed to be some indication that it had like the lowest press coverage about this case in the state. So it was going to be the most likely place to get jurors who hadn't already made up their minds because of what they'd read about it in the media. But it's also Judge Gull's. It's her county. It's where she's a judge. Is her convenience a factor in it? Maybe, probably. I don't know, but it could be. So I don't have a good answer for why not Indy in that situation. I think site-wise, Delphi does make sense, but as far as pulling the jury from Indy, why not? Yeah, I don't know. Probably, I'm guessing convenience. Michelle J. for hand warmers and lunch. Thanks, Andrea. Well, thank you so much. I hopefully won't need hand warmers. Although it is several weeks still to go here. Supposed to be getting warm again as we get towards the weekend. So we'll see. But yeah, it's wetter here than it is where I come from. So maybe I'll get a hood if that's okay with you. Maybe I'll get like a hood. I don't have good rainwear. You don't need it when you get 6 inches of rain a year where you live. So K-Rab with a $10 super sticker. Thank you so much for that. M has gifted 5 memberships. Thank you for that. Thank you on behalf of everybody who got one of those. Jen Lee 143. I live in Indiana. I thought he was guilty until YouTube. I'm thankful you are so committed. I want the truth. Well, thank you. And I can't tell you. Okay, I'll try. I'll try to tell you. 15 years roughly as a criminal defense lawyer, it's real easy to get jaded. It's real easy to get jaded. I saw this panel today and it was like bringing life back to me. I would have loved to have had this panel in so many trials because you just get used to a lot of unfairness. You start to expect it. You start to consider it normal. And things have changed a lot culturally in a surprising short period of time. At least, I mean, that's just obviously just my perspective. But I have seen a big shift from when I was first starting as a little baby lawyer, taking things to trial, and the faith in law enforcement and the prosecution pretty much unquestioning, and just the instant assumption, the guy is sitting there at the table, I wonder what he did, and I wonder what lies she's going to tell us to try to help him get away with it. It's just a rough attitude. And so it's so heartening to me to see it's not universal. That's not everywhere. It's not everybody. There are people who care about the truth, like you, Jen Lee 143. Thank you. I realize it seems like a strange thing to thank you for, but thank you for caring about the truth and not just taking it for granted that because this gentleman was arrested that he must be guilty, and therefore we don't really need to pay attention to the reasons for locking him up and throwing away the key. It does matter. The truth is critical. Lila, hello from Mexico, and thank you. Well, hello, buenas noches. Thank you so much for being here. Really appreciate it. Tim Harris, can they still use peremptories on today's 14 tomorrow? Seems like they should be able to. Also, why do they do mini openings with the whole jury? So really good questions. The way that the peremptories work is that they get a certain number for the jury, for the 12 that will be seated. If I remember off the top of my head, it's 6. So they get a fixed number for that, and then they get a fixed number for the alternates. So for 4 alternates, they each get 2. So no, the answer is they do not, like if they didn't use all their peremptories for the jury as a whole, those are not going to carry over to the selection of the alternates. They just get their 2 for the alternates. That's how they do it in Indiana. It's not how they did it where I was from, and that's in part because in most of the courts that I practiced in, they would do randomized selection of the alternates. So instead of it being always the last 4 or something like that, you would like draw them out of a hat. And that's helpful. It's beneficial, I think, in a lot of ways, because if you know you're the alternate, you just, it's human nature. It's not maybe going to be as important to you because you think it's less likely that you're going to be involved in the ultimate decision. So it's just easier to zone out, easier to pay attention to other things or whatever. If you don't know you're the alternate until the end, then you're going to be more focused and attentive. This is the theory anyway. But that's not how they do it in Indiana. It's clear they've already picked the 12 that are the primary. They are now picking the alternates specifically, so the alternates will know that they are alternates. In fact, it's come up in questioning and been talked about, the fact that alternates aren't going to participate in deliberations unless you're called upon by the judge. Is that going to be a problem for you? Kind of questions. So short answer, no, they get They use or lose their peremptories on the jury as a whole, and then they have 2 just for the alternates. Also, why do they do many openings with the whole without the whole jury? So I think the way that it works is they will get to do it again tomorrow for the new panel. So they'll do it for each panel of 50 or whatever that's brought in. As it turns out, they're only going to need 2. I like the idea of the many openings in general. We did not do this in Washington, but it just helps orient them in terms of what do you need to expect? What sorts of things do you need to be thinking about? What sorts of triggers might there be for you? What sorts of biases might this raise that you don't get from just the bland, these are the charges. The more specifics, I think, allows them to just be more careful with the types of questions that they ask and the type of information that they try to get from those jurors. So they'll do full openings, when they have their sworn jury, of course. But for this purpose, my expectation is that they will do the mini opening again tomorrow. I'll let you know tomorrow if that's how that rolls. Sarita Banana for some court snacks. Thank you, Andrea. Thank you very much. I went into the courtroom today with my yellow legal pad, my pens, and my car key. That was all I dared to bring. And so I did actually have snacks in my car, just never had a moment to go out to the car to eat them. So that's okay. I had snacks on the way home. It was all fine. Ian Moran is a YouTube member. Welcome. Thank you so much for joining. Dr. Von Decay, what did he have on? What did he wear? So all I was able to see was the top. I didn't see what he had on, below the waist. I didn't see if he had like a stun belt. He's not shackled. You're not allowed to be shackled in front of a jury. So his hands are free. He's able to move and stuff like that. Feet, likewise, there's nothing visible. At the same time, not unheard of for people to have the stun belt underneath their clothing in the trial setting if it's subtle and the jury isn't likely to see it. So what I saw him wearing was a plain collared shirt, no jacket, no tie. It's a white shirt. It had a little bit of a pinkish tone to it. It looked like there was maybe a pink stripe or a pink check or something like that, like a very fine pattern that, he's far enough away from me. I can't see the detail of it, but I just get that pinkish kind of glow from it. Yeah, that's what he wore. And it worked. It worked. People have whole different approaches to courtroom attire for defendants. I personally like that he wasn't in a suit, like a full suit. Because he's not a lawyer. And so trying to dress him up like one, it's not fooling anybody. It doesn't fit. It's just incongruous. It doesn't, he's not a suit guy. Like, I just don't get that. I don't get that from him. So trying to force him into that, I think would have just been uncomfortable and would have just kind of looked fake. It would have contributed to an authenticity issue that you don't want to have with something basic like that. So I thought his clothing was good and appropriate, and it suited him. Dawn, can she legally block people eat lunch during trial? Yep, she sure can. The judge is pretty much God in the courtroom as far as managing the schedule and breaks and things like that. May not be wise for all kinds of reasons, but in terms of like, how are you going to stop her? It's her discretion. What can you do? Go up to the Supreme Court and try to get a writ? They're not going to writ her. They're not going to give a writ of mandamus to let people have lunch. So Well, suck it up. This is kind of part of the trial. It's, it's trial. It's trial by jury is also trial by fire. I mean, this one in particular, this is going to be a marathon. This is not just going to be a marathon. This is going to be a marathon in the Himalayas. Like, this is going to be extremely challenging. I don't envy these lawyers, the work that they're going to have, the distance that they are from home to do it in. It does look like one of the questions I had about scheduling today that I don't think we have a definitive answer to yet, but we have some good ideas. Way back in when trial was set in May originally, I think that's when it was. The judge had talked about going through on Saturdays as well, having trial on Saturdays. So basically 6 days a week in court, 1 day off. And there was a question about whether that is still going to be the case now. It's not clear. There do appear to be a couple of Saturdays on the court calendar, but not all of them. So it looks like there's going to be at least a couple of 6-day weeks, unless, something about that changes, or unless that was a mistake. Kind of hard to say. So it's just understood to some extent. There's a lot of hardship involved when you go to trial, and it's just part of the process, part of what you endure. Some judges make it a little bit more of a hazing than others. You can draw your own conclusions about which one of those Judge Gull is. Haywood Jablome. I live in Kennewick, Washington, different from Indiana. Well, isn't it? Isn't it quite a bit different? I've so much of my driving in Indiana so far has been in the dark. I got here, I flew into Indianapolis, drove out here, mostly in the dark. Drove to Delphi yesterday because I woke up super early in the morning, drove over in the dark. Got up super early this morning to go to Fort Wayne. I was on the road at 5 in the morning, very dark. I haven't hardly even gotten to see much of Indiana. What I have seen is very beautiful. The colors are turning now. The fall colors are turning. The forests here, these are beautiful mixed forests. So lots of different deciduous trees and maples, oaks, ones that I don't recognize them because they don't have them near me. But all these trees starting to turn, so all kinds of different colors. It's really spectacular. It's a little bit more hilly over here than it was closer to Indianapolis. My first impression of Indiana was, holy cow, this place is flat. I thought Delaware was flat. This place is flat. It is a little bit hillier out here in this part of the country. So yeah, my initial impressions of Indiana is very flat. Gas is cheap. There's a lot of roadkill. There's like a raccoon on the ground every few hundred yards. A lot of roadkill. I guess that just speaks to how many animals are out there in those woods. There was a pony though. There was a pony. Roadkill pony. Ugh, never seen that before. I'll remember that about Indiana for sure. But yeah, in general, quite a bit different here than my little arid corner of the world over there in Washington. All right, guys. That's all we got for your questions, your comments, your chats. Thank you again for your support. Really means a lot to me to have you guys here with me, supporting this, showing interest in this case. Just sharing my concern that this process be fair and that this process elicit the truth. And that's what these victims deserve. That's what justice is. So just very, very important to have the eyes on this. And I'm glad to have the other folks there that I I rely on and I support. Lawyer Lee in particular, a lot of respect for her and what she does. I know Bob Motta at Defense Diaries is planning to be here as well, but I don't think he's coming until Friday. He didn't make it for jury selection today. But just another good legal mind, to follow for insight on this case. I know Bob has followed this for quite a long time too, and in some detail. So good folks out there to follow. I feel good about the environment. I feel like most of the people that were there today, we're all on, we share a mission, I didn't get a real sense of, people being territorial or trying to get their scoop or anything like that. Like, everybody recognizes this case should have more attention. This case should be more transparent. It should be more visible. And so I'm optimistic that there's going to be ways to share information, even if the seating is limited, even if, I may not be able to get in every day. I may not be able to get in at all. I'm certainly going to try absolutely my best. But just recognizing the limitations that are there, I have to appreciate, it might not happen. It might not happen, or it might not happen consistently. And so we might be scrambling to get backup sources. So got a very good feeling about the folks that were there today, and just the willingness to share, to not, feel like this story belongs to somebody or some outlet or anything like that. It really does belong to the public, and it needs to be out there. So all in all, good Monday, good first day, encouraging. Normally I might be a little bit alarmed to have a jury, to be so close to having a jury selected so early and out of so few people. But having seen the panel and gotten the feel for kind of why that is, how it's worked out that way, I'm not so alarmed. I'm not so troubled. I do feel good about this panel. I feel mostly good about the jurors that have been selected. I feel like there's been a good focus on the things that matter for jurors to be able to be fair, the things that they need to be thinking about, and just the attitude that they need to bring to the process. It's been vetted. They had good material to work with. So I do have a good feeling about this jury so far. So now we just get it done and start getting ready to move on to the evidence phase. So I'm going to go ahead and sign off now, guys. I'm going to be not quite as early tomorrow. I don't think I need to get there as early as I did today, now that I, have a sense of the crowd and the capacity and everything. But it's still going to be an early morning. It's a bit of a drive. And of course there's road work like the entire way. So lanes shut down and all this stuff. Whatever. I don't need to complain about that kind of thing. But I am going to go ahead and sign off and get ready to get to sleep. Do this all again tomorrow, and I'll plan to come back and let you know how things unfold. I'm particularly interested in the resolution of the final motions and see what we can learn from that. This is that motion to try to exclude the defense expert. This is really like the last shot at trying to shut down the defense's ability to defend. If they're not allowed to argue that pseudoscience is pseudoscience, then I just am not going to have a lot of illusions about the fairness of this process, or frankly, the likelihood that a conviction would stick, which I already question in light of some of the pretrial rulings. The exclusion of the third-party suspect evidence, very, very problematic in my mind. So certainly going to be an issue on appeal, and one that from my perspective, these are hard issues to win, but this is about as strong a case I've seen for reversal on that type of issue as any. So with that, thank you again, everybody, for all of your support. Thank you for being here. Thank you for chatting. Thank you for the great vibe that you get going there in that chat. Thank you, mods, all of you now, the team that we have, keeping things rolling, keeping things going smoothly. I appreciate all of you so much. I appreciate your support, making this, not just making this happen because you get, you help me with super chats, you subscribe to my Substack, yada, yada. Obviously that helps and it's important and I appreciate that very much. But just knowing that this matters to so many people, it does. It gives me so much confidence in a system that it's easy to start to lose faith in after all these years in it. It's so wonderful to be reminded how many people care and how many people value real justice, real truth, fairness, a clean process. So thank you to all of you for that. I appreciate all of you, and I look forward to seeing you again tomorrow after another day in trial. Take care, guys.